Yes.
My Lord, Your Ladyships. I had just taken you to the passages from Korean Syndicate and Wesley, where Lord Justice Atkin and Sir Ernest Pollock had looked at Mr. Justice Rowlatt's analysis in marine steam turbine. I'm going to come on and look at that in a moment. But just one logistical question. In terms of managing time, it would be helpful for, I think, both sides to know what time the court was proposing to sit.
Normally this court rises at 4:15, but you can have a few minutes beyond that if really needed. But we certainly can't go beyond 4:25 at the latest.
Okay, I'm grateful for that indication, my Lord. So if I could turn then to marine steam turbine, that is tab 10 in the authorities bundle. It's a decision, as I indicated, Mr. Justice Rowlatt in the High Court. And it's page 208 is where it starts. Now, just to note, that was a decision that was handed down before the run of cases in the Court of Appeal and the House of Lords that I've just shown you, so Korean Syndicate, Wesley and South Bahar. Similar to a number of the earlier cases, it was an excess profits duty case about whether an entity was carrying on a trade or business, and that was defined as all trades or businesses, whether continuously carried on or not, of any description carried on in the UK. Brief summary of the facts. It concerned a company which was referred to as Old Co, which had a license from an inventor and patentee to manufacture and sell a particular engine. It built an experimental test ship which worked, and it was thought that this product would be so lucrative that the best thing to do would be to put that company into voluntary liquidation, the liquidators to assign the license to a new company in return for cash, shares, and importantly, a royalty for a term of years by reference to the number of engines sold by the new company. That right to royalties generated very large sums in Old Co, and the winding up was stayed. And you can see it for your note, I don't propose to go to it, but it's page 210. In the relevant period, aside from amending slightly the agreement with New Co, which it said did not substantially alter the position, Old Co did nothing except receive royalties under the agreement and distribute dividends. So the issue was, in effect, was that receipt of royalties a trade or business? And if we go to page 217, which is the start of the judgment, Miss Justice Rowlatt holds in the third line of the judgment, in my judgment, the appeal of the Crown fails. So it was the Crown seeking to maintain that this was a business. Lower down that page, and in line with my earlier submissions that the concept is very broad, it has been said on behalf of the appellants that the word business is a very wide word. That word, in whichever sense to be understood, is undoubtedly an elastic word capable of wide extension, but it must be borne in mind that it is also a word which has two virtually distinct meanings. It may mean any particular matter or affair of serious importance, and then goes on to give some examples. And then over the page, which is really the important page for our purposes, paragraph beginning a fifth of the way down the page, the word business, however, is also used in another and very different sense as meaning an active occupation or profession continuously carried on, and it is in this sense that the word is used in the act with which we are here concerned.
How does this help us when your submission is that this is all wrong?
Well, my Lord, I'm going to have to show you how it helps, but I'll show you a later decision of Mr. Justice Rowlatt.
Why can't we just go straight to the later decision if you're saying that the later one is right? Because I mean, this is flat inconsistent with the
later cases. Indeed, my Lord. I just want to show you. It was really to show you the context for a statement that Mr. Justice Rowlatt makes in a later case, which I'm about to take you to.
Okay.
And then just at the bottom of that page, so that's the first passage that I've just shown you, the active occupational profession continuously carried on. Lower down, if any private person occupied the position which the respondent company occupies, it would be almost ludicrous to speak of him as carrying on a business. Now, in my submission, in light of the subsequent case law, and to some extent as my Lord has indicated, there are two clear and significant errors in that reasoning. The second is in the passage that we've just seen of equating the position of a private person and a limited company, and thereby failing to apply what I've described as the strong presumption. And the first is in the earlier passage on that page 218 of holding that a business must constitute an active occupation continuously carried on. And my submission that I'm going to come on to make is that the First Tribunal in this case essentially made the same two errors. Now, again, to follow through on what I just said to my Lord, It is interesting to look at one final judgment of Mr. Justice Rowlett, and that is the Tyre Investment Trust Company case, which is at tab 13. Unfortunately, I'm not sure why, but we have a Lexis printer. I think it's because it's only in tax cases, but be that as it may. This is a decision handed down after the Court of Appeal decisions in Korean Syndicate and Westley. It's interesting to some extent for its finding that a holding company can carry on business. But the reason specifically to refer to it is the first two paragraphs of the judgment. They are on page 291. And if I could just ask the court to read those first two paragraphs. So 2 points. The first is his lordship, they're recognising that the authorities have moved in this period. So it's really in that period in the early 1920s where the authorities on the meaning of business shift, as his lordship says, and he refers to the darkest days of his error as to the necessity of an active carrying on of business. And that's the position he'd adopted in both Marine Steam Turbine, which we've just seen, the first instance decisions or the High Court decisions in Westley, the three cases there. His lordship had thought you required an active carrying on, but by this stage, his lordship recognises that that was an error. Final point that I need to make in relation to the necessary degree of activity is just to contrast the position of UK tax law and the position in US tax law. Now, the court will recognise there's a point that I come on to make, that the tribunal was at least influenced and may well have been applying the US tax law test. I just need to show you the relevant bits of the material on that point. The US experts addressed at some length the necessary requirements to be what is referred in the US as engaged in a trade or business in the US, or ETBUS, that's the acronym that they use, engaged in trade or business US. Two reports that we have. The first is that of Mr. Shashi, who was GEFI's expert. That is in the supplementary bundle at tab 87. If you could start at page 798. If you could just read paragraph 2, that's the summary of Mr. Shashi's opinion. Now, the analysis that's the summary of his conclusion. The analysis for arriving at that conclusion is at page 802 to 807. If I could ask you to turn to 803. And read from having said that, which is about halfway up the page, to the first word over the page, which is business. Place particular reliance on the reference to significant, producing activity that is significant, is both regularly and continuously carried on in the United States. Isolated commercial activity, and then further down, occasional activity, not enough. If we flick forward 2 pages to 805, and again, it's worth reading the whole of the analysis, but I'm just pointing to the passages or the excerpts I rely on. End of the first paragraph on 805, whether the LP's activities were sufficiently substantial, regular, and continuous. Bottom of the next paragraph, the IRS found that the activities were continuous and regular. And then bottom of that page, and here they're looking at IRS examples, or Mr. Shashi is. The IRS concluded that the fund, through the fund manager, engaged in lending and stock distribution activities within the US that were considerable, continuous, and regular. Consequently, the IRS treated the fund as engaged in a US trade or business. And then the last passage that I want to place particular reliance on is on the next page, 806. And as it were, if the court could try and hold this passage in its mind, because I mean, I can take you back to it if we need to, but it's worth just remembering the turn of phrase. Holding 5 affiliate loans over the course of approximately 6 years, only 3 of which originated with the LP, is likely to be considered activity that is passive, sporadic, or isolated, rather than regular and continuous. Now, we will see that that is a phrase that the First Tribunal essentially cuts and pastes into its decision in paragraph 84. For completeness, I should show you the passages from HMRC's expert. That's Mr. Miller. You'll note the analysis is at page 842 to 847, but we only need to look at 843 and 844. And the statements are to a very similar effect, as one would expect, because the experts said they had no material disagreement. But at 843, this is in tab 88, I should have said, sorry. You have in paragraph 37, as a general rule, some material degree of regular and continuous activity seems to be required for a foreign person to be et bus. And then over the page, paragraph 40, you have a similar conclusion to Mr. Shashi in paragraph 40. It seems to me unlikely that the level of activity conducted by LP, even if all within the US, would be sufficient to cause LP to be et bus. And if you'll note, the First Tribunal summarised that expert evidence in paragraph 32 of its decision, and it identified a requirement in the US for what it called regular and continuous activity, so adopting some of the phraseology used in those experts' reports. Now, in my submission, the US law position that emerges from those expert reports is clearly different to the position in UK law. There is a clear requirement for extensive activity. We've seen it variously referred to as substantial, regular, and continuous. And it's not enough to have passive, sporadic, and isolated rather than regular and continuous activity. My submission, the US law test is much closer to the analysis of Mr. Justice Rowlett in Marine Steam Turbine, which focuses on a requirement for an active carrying on of the business, and there being no strong presumption that a company is carrying on business. In my submission, the Court of Appeal decisions and the American leaf blending case that I've shown to you demonstrate that that is not the correct analysis for UK tax law purposes. And I'm going to come on to submit that the FTT was at least influenced by that US law test and may even have been directly applying that test at paragraph 84. And that is one of the errors of law that GEFI identify in the FTT decision. That's the end of the third principle. We have 4 and 5 left to go. Happily, 5 is very short. Principle 4 is that the purpose or object for which a company is formed, as set out in its memorandum, is a relevant factor in determining whether it's carrying on a business. And we see that most clearly in both the Westley and the American leaf blending decisions.
Sorry, can you reformulate that? I was busy sneezing.
Sorry, my lady. The purpose or object for which a company is formed, as set out in its memorandum, is a relevant factor in determining whether it is carrying on a business.
Yep.
And I was saying that's most clearly seen in Westley in the American leaf blending case. So as far as Westley is concerned, if we can go to page 261 of the authorities. It's tab 12, sorry, I should have said. And it's just before the passage that I asked the court to read earlier. So it's 4 lines down. It may be well to remark, if you could read that down to where it refers to Lord Justice Atkin. So the mere fact that you're doing something within your objects as a company is not enough. But if its objects are business objects and are in fact carried out, it follows that the company carries on business. First statement. If we then look at Lord Justice Warrington, 269, a few pages on. About a third of the way down the page. I think the facts found by the commissioners result in this. The company was formed with certain objects. And I should say those objects for your note are on the previous page, or his lordship refers to them on the previous page at the bottom of 268. They have done various things in pursuit of one or other of those objects, and they have thereby derived profits. I've already said that in my opinion the description of the objects is the description of a trade or business. It follows that in my judgment the company have been and are carrying on a trade or business. So in my submission, what the majority of the Court of Appeal, and indeed the Court of Appeal are unanimous on the point, are saying is that if a company is carrying out its objects, and its objects are business objects, then it follows that the company is carrying on business. Now, Lord Diplock in the American leaf blending case refined that analysis somewhat, and we can see that, tab 19, page 400. And if I could ask the court to read from just below capital E on 400 down to the bottom of the page, so where the side ruling is. Now, as Lordship first of all notes, that the special commissioners in that case, as I identified when I was setting out the facts, had held in effect that the mere fact that the company was doing something that it was permitted to do by its objects was sufficient in law to mean that it was carrying on business. And Lord Diplock says, well, actually, that analysis does derive some support from Westley, the Westley decision, which we've looked at, but then distinguishes Westley on the basis that that was a case where the company was carrying on what he called the principal object stated in its memorandum. And we can see in this case, Lord Diplock had already identified that the company in American leaf blending was not carrying on one of its principal objects. We can see that at page 397 if we turn back a few pages. At E on 397, appellant taxpayer was incorporated in 1960. The principal object for which it was established was to cut and blend tobacco and to manufacture cigarettes. So here, the Privy Council was looking at letting, which was not the principal object of the company. And Lord Diplock says the Privy Council wouldn't endorse the view that every isolated act of a kind that is authorised by its memorandum, if done by a company, necessarily constitutes the carrying on of a business. In my submission, 2 points arise from Lord Diplock's analysis. First point, Lord Diplock did not hold that the approach in Westley was wrong on the facts of that case. Indeed, if anything, he could be said to have endorsed it. But he limited it to where the company was carrying on its principal objects. So Westley, in effect, is to be read as saying, if you're carrying on your principal objects as a company, you are necessarily carrying on business. The second point I draw is that this really re-emphasises the point about the incredibly low threshold that business poses as a test. What the court is saying here is that the fact that a company carries out any act that it is authorised to carry on does not necessarily mean that it's carrying on business. Now, it recognises that such an isolated act may be sufficient to constitute carrying on business, but in my submission, the very fact that the Privy Council needed to address that point at all does rather illustrate what a low threshold business is for a company. So I draw 3 points from that look at Westley and American leaf blending. The first, just to remake the point that I've already made, that it is a very low threshold. Second, the objects of the company are relevant to whether that company is carrying on business. And third, the more nuanced analysis of Westley in American Leaf Blending, if a company is carrying on one of its principal objects, and that is a business object, then it is carrying on business. The final legal principle that I draw, I can deal with much more briefly. It's in the passage that you've just read, and that is that the question of whether a business is being carried on in any particular case is a question of fact. And that you could see from page 400, the passage I just got the court to read above capital F. Now, I fully accept that whether in any given case a company is carrying on a business is an evaluative question of fact. So it's not a primary finding, but it's a secondary or evaluative finding. However, the court already has my submission that the meaning of the concept of business for UK tax purposes, in my submission, is a question of law. And in my submission, the cases demonstrate that that meaning is informed by the first four legal principles that I've identified.
With respect, which of your first four principles attaches any meaning to the word business?
Well, again, my lord, it depends what one means by meaning. But if one is asked...
You've told us it's a broad concept, it's a low threshold. You tell us that there's a distinction between individuals and companies, and you speak of a strong presumption. You say you don't have to be active, and so on. But none of that gives it any meaning.
Well, my lord, I wouldn't accept that proposition for a moment. In my submission, they all go to the meaning of the concept. So, for example, if the tribunal...
Tell us what you say it means.
Well, if I could adopt what Lord Diplock, the way Lord Diplock analyses it in American Leaf Blending, and probably no higher authority than that, his lordship says we give it the ordinary meaning of business.
And then it's a question of fact.
No, my lord, I don't accept that, because that ordinary meaning is informed by all of these principles. So to take an example, if a court were to say, we are presented in a UK tax law case with the question of whether something is carrying on a business, I take that to be a very narrow concept that will only be satisfied where a company is engaged day to day in trading activity or business activity of some kind. I treat it in exactly the same way as an individual would, or I would treat an individual carrying on the same activity. If a tribunal were to say those things in the context of determining the meaning and application, it would be wrong, because it would have misapplied all of those legal principles which I have identified. Now, my lord may be saying that there is nothing that says business means, quotation marks, X. In my submission, that is not the only thing that meaning can mean. If you're asking what a word means, if there are certain principles that are identified to determining whether something satisfies that meaning, that gives the concept.
Let me approach the question in a different way.
Yes, my lord.
You have accepted, I think, that the word carries its ordinary meaning, and that is to say it bears its dictionary meaning. Yes?
No, I don't accept that either.
Oh, right. So if it doesn't bear its dictionary meaning, where do we look, if not in the dictionary?
You can certainly look at the dictionary, my lord. I mean, we're rather getting into broader questions of statutory or other construction. Clearly, the dictionary meaning would be something one can look at. I don't deny that. One can't simply say it takes its dictionary meaning full stop. But the significant point in my submission is that the meaning the concept has for UK tax law purposes is underpinned by these principles. If one doesn't apply those principles in determining whether the concept is satisfied, then one has made an error of law. And that is my submission. And to remake the point...
But certainly you have not offered any alternative meaning to the dictionary meaning.
I haven't sought to set out a sentence that defines business. No, I have said that the concept is underpinned.
You accept it's the ordinary meaning.
And that's what Lord Diplock said. But then Lord Diplock went on to say, and to apply the principles that he did.
Indeed.
So he was applying the ordinary meaning, but it's clearly undergirded by those principles. My Lord, if I can come on very briefly to deal with the Lord Fisher factors, which featured in the FTT decision. They were developed in the context of VAT in the Morrison's Academy case and the Lord Fisher case, and then were applied by the Upper Tribunal in the direct tax case of Ramsey. They are 5 indicia or factors that are relevant, said to be relevant to whether an entity or a person is carrying on a business. There is a sixth factor, but that's specific to VAT, and nobody has suggested that that would be relevant in this context. Those factors...
Is it established that these apply in direct tax as well as indirect tax? Is anybody saying
well,
not read across?
They've been applied by the Upper Tribunal.
Yeah, but at this level.
I'm going to come on to make submissions on them, but my submission is a tribunal is perfectly entitled to have regard to these as factors to consider.
Yep.
But I do not put them at the point of saying that they are legal principles that guide the meaning. They are factors.
No, there's no other Court of Appeal case above where the
Ramsey is what we have.
sort of thing. Okay.
Not that Ramsey. It's Ramsey.
Different Ramsey.
So, just briefly, those 5 factors ask whether the activities constituted a serious undertaking earnestly pursued or a serious occupation, were an occupational function actively pursued with reasonable or recognisable continuity. 3rd, had a certain amount of substance in terms of turnover. 4th, were conducted in a regular manner and on sound and recognised business principles. And 5th, were of a kind which, subject to differences in detail, are commonly carried on by those who seek to profit from them. My submissions on the Fisher factors, 3 short points. As I've already submitted, they are factors certainly to which a tribunal may have regard. They go to the factual evaluation of whether a person or an entity is carrying on a business, and the relevance of each factor may vary depending on the circumstances of the case. But as I've already submitted, hopefully in answer to Valerie's question, in my submission, they are not legal principles that go to the meaning of business for UK tax law purposes. And that analysis in my submission is consistent with that of Mr. Justice Gibson in Lord Fisher itself. I don't propose to go to it, but it's for your note, it's tab 20, page 411H, where his lordship referred to those indicia as useful tools, some perhaps more than others. And the Upper Tribunal in this case was, in my submission, correct to hold that they should be used with caution, as indeed they were in Lord Fisher itself. The skeleton then goes on to give a number of examples, of factual examples, to show cases where limited activity has led to the finding of a business. I don't need to address those. The only point I do need to address is just the point about receiving payments and what was said in South Bahar about that, because the First Tribunal did expressly rely on that. If we could go to page 304, tab 14. This is Lord Sumner again in the South Bahar case. So halfway way down the page, it is obvious too that during its present period of dormant life, so this is when the company is just receiving annuities, it has very little to do. I do not attach much importance to the domestic operations of declaring and paying dividends, remunerating directors and presenting reports. But the operation of receiving and thus discharging the annuity payments goes on continuously, and however simple, it is not a mere passive acquiescence, it is the transaction of business between debtor and creditor, resulting periodically in the discharge of a debt. So what his lordship was saying was that every receipt of an annuity payment is, in his lordship's terms, the transaction of business. And that's relevant because the First Tribunal relies on that passage in a way that I will come on to submit as an error of law. The FTT fundamentally misunderstands what Lord Sumner was saying. The final part of GEFI's positive case on issue 2A, and I'll try and take this quite quickly, but that is to apply the legal principles that I've identified to the facts of this case. The key factors that GEFI rely on are set out in paragraph 56 of the skeleton. I don't propose to read those out, but I would just make the following points by way of elaboration. First point is to say it is not suggested for a moment that the LP was a hive of daily activity. That has never been GEFI's case. It has never been something that GEFI has submitted. But the LP did carry out very substantial transactions. It ultimately held loan receivables in excess of $2.8 billion, and it received interest of in excess of $700 million throughout the relevant period. And the loans were used in particular by Gelco to fund its fleet leasing business in the US. Now, standing back for a moment, and again, to some extent this may be a jury point, but if one were to ask the man on Clapham Omnibus, is an entity that's holding $3 billion of loans, receiving $700 million of interest, is that carrying on business? In my submission, you would get only one answer. Now, importantly, all of those activities, all the loans, were properly executed by GEFI Inc. as the general partner of the LP. There is no suggestion that the transactions were a sham or that they were not carried out in a legally effective manner. They were real transactions. The FTT's real difficulty with the transaction seems to have been the extensive involvement of the GE tax group and treasury team in the transactions. And again, that involvement can be seen from the emails. No one's seeking to shy away from that. But in my submission, it should be no surprise or any source of criticism that the treasury and tax team in a multinational group is heavily involved in a group financing function. Now, to take one example, the First Tier Tribunal at paragraph 86 points to the fact that the interest rates were determined for what it said, for benchmarking as opposed to commercial purposes. Now, it's not entirely clear what the FTT means by benchmarking, but in my submission, it's clear from the emails that the FTT cited, for example, at paragraphs 16 and 17, that the GE staff were clearly seeking to ensure that the loans were priced at a market rate of interest. It is also, in my submission, fair to say that HMRC would be deeply critical of a company and a multinational group as well if their tax and treasury team were not heavily involved in the group financing in order to ensure that that entity's lending was transfer pricing compliant. The final point I'd make in this context is that it is also important that in applying the Fisher factors, which the FTT did, it held that the LP's activities constituted a serious undertaking, that's at 83 of the decision, the sums involved were substantial, that's paragraph 84, most importantly, that the loans were conducted on sound and recognised business principles, that's at 84, and I place significant weight on the word business. Now, the FTT didn't address one of the Fisher factors, but in my submission, it must also be the case that making loans at a market rate is the kind of activity that is, quote, commonly carried on by those who seek to profit from them. So in my submission, it's clear that the LP's activities satisfied 4 of the 5 Fisher factors. Now, I am not submitting that this is an exercise in factor counting. But what I am submitting is that if the tribunal had proceeded on the correct legal basis as to the meaning of business, given that concept's low threshold, given the strong presumption that a limited company putting its assets to gainful use is carrying on a business, and given that there's no legal requirement for the company to carry on extensive and regular activity, then the only reasonable conclusion on the facts of this case was that GEFI was carrying on business throughout the relevant period. And that is the basis on which GEFI maintains that this court should determine this appeal after setting aside the decision of the FTT. So I now need to go on and show the court what the FTT's errors of law were. So that's stage 3 of my submissions. The FTT's conclusion is summarised at paragraph 91. Having regard to the degree of activity as a whole, particularly the lack of participation in the strategic direction of the LP by the directors of GEFI Inc., GEFI was not carrying on business in the US through its participation in the LP. Paragraph 61 to 68 sets out what I take to be the errors of law in the FTT decision. But pausing there, it is worth just addressing the nature of the debate here, because a significant proportion of my learned friend's skeleton argument on issue 2A involves citing authorities concerned with challenging first instance decisions. Now, that's perhaps not surprising where HMRC won at first instance. But HMRC repeatedly assert or imply that GEFI's case is a challenge to the FTT's evaluative finding of fact that GEFI was not carrying on a business, what is sometimes referred to as an Edwards and Bairstow challenge. Now, that is obviously a notoriously high hurdle. One needs to show that no reasonable tribunal could have arrived at the conclusion that the FTT arrived at. So just as an example, paragraph 17 of the skeleton, it is said, the so-called errors identified by GEFI are in reality not material errors of law at all, rather they are complaints about the FTT's evaluation, in particular the weight the FTT attributed to different factors. In order to show that the FTT erred in law, GEFI must show that the only reasonable conclusion open to the tribunal was that this factual matrix established that the limited partnership and thus GEFI was carrying on a business. In my submission, that is simply not correct. The errors in the FTT decision identified in our skeleton argument, paragraph 62 to 68, are, in my submission, all conventional errors of law. You have my submission that the FTT failed to apply the correct test as to the meaning of business and that constitutes an error in the reasoning of the First Tribunal. It is not a challenge to the FTT's factual evaluation.
Can I take it you wouldn't dispute the applicability in this context of the principle that was articulated perhaps most famously by Baroness Hale in the, I forget what the initials were, Sudan case in the Supreme Court, where she said that where you're dealing with specialist tribunals, and I take it everybody accepts that the FTT tax chamber is a specialist tribunal, then the appellate tribunals and courts should not rush to find, or should be very cautious before accepting the suggestion that they've misdirected themselves in law when considering what are essentially findings of fact.
My Lord, I would accept that this court, and there are many authorities to the effect that this court should treat a specialist tribunal with a degree of respect. I fully accept that. Equally, there are probably just as many decisions in which this court or the Supreme Court has found that a First Tribunal has made an error of law in arriving at what is ultimately an evaluative factual finding. So yes, one shouldn't jump to the assumption or jump to the conclusion that the tribunal has got it wrong. It is a specialist tribunal. But equally, one should read the decision, see what principles the tribunal identifies. Here we will see none. See what principles the tribunal applied. Here, again, none. And on that basis, determine whether the First Tribunal made an error of law. And it's plainly open to this court to hold that the tribunal did make an error of law at that point. But on that basis, much of that section of I should say, aside from one final ground of appeal, which is dealt with briefly at paragraph 80 of the skeleton, which isn't, it's a sort of fallback Edwards-Bairstow challenge, which I'll come on to very briefly. The other challenges in my submission are all conventional errors of law. On that basis, in my submission, a lot of the authorities in the section paragraphs 18 to 26 of the letter friend skeleton argument are either entirely uncontroversial, like the Kuna and Nagel passage and the Eclipse Court of Appeal passage, or are simply beside the point because they don't address the nature of the challenge that GEFI is making to the First Tribunal decision. Just 2 points to make on that section, though. First, I've already accepted it's correct that the main focus of this appeal should be on the FTT, subject to the one bit of the Upper Tribunal decision I'm going to need to look at. Secondly, I fully accept that the error of law must be material, and that the relevant authority there is de Gauss. But it is important to recall the test of materiality identified by the Court of Appeal in that case, which is not set out in my letter friend skeleton argument. So if I could ask you just to go, it's in the authorities bundle, tab 38, page 8.
I think we're familiar.
Familiar with it. Well, my lady, the only point I would make, as I'm sure my lady will have appreciated, the test is that it might not would have caused the FTT to come to a different conclusion.
Yeah.
So returning then to the FTT's errors of law, the skeleton identifies what I've termed 3 fundamental errors and then 3 further errors. They are less fundamental but still material. You already have my submission. Each error is sufficient in my submission without more for the court to set the FTT decision aside. For each of them, I propose to identify the error, address the Upper Tribunal's reasoning for holding that it wasn't a material error, because ultimately that's the Upper Tribunal's conclusion, is to say there may have been errors here, but they're not material. And then thirdly, to address the arguments raised in HMRC's skeleton argument on the point. So, fundamental errors. The first fundamental error in my submission is the failure to apply the strong presumption that GEFI Limited, as a limited company, gainfully deploying its assets, was carrying on business. You have my submission. This is an important aspect of the meaning of business for the purposes of UK tax law. And in my submission, it does not feature in the FTT's reasoning in any way, shape or form. If it had done so, the FTT's reasoning would have looked significantly different, because it would have had to start from the strong presumption that GEFI Limited was carrying on business, and then identify if there was a sufficient basis on the facts to overcome that presumption. And that is simply not what the First Tribunal did. What the First Tribunal did was to simply look at the Lord Fisher factors and come to a conclusion based on applying those factors, which is what the Upper Tribunal also did in Ramsey. This Ramsey, not that Ramsey. But in my submission, the fundamental point here is that both Ramsey and Lord Fisher were cases concerned with whether individuals were carrying on business. So there was no reason to apply the presumption in those cases. Now, the Upper Tribunal says at one point that the reasoning in Ramsey and Fisher is not confined to individuals. But, I mean, in a sense of necessity, of course it was, because it was an individual that was before the Upper Tribunal and the High Court in both cases. If it had been a company, and if those cases hadn't applied the strong presumption, they too would have been wrong. So my submission, the failure of the First Tribunal to apply the strong presumption in this case is a clear error of law because they are applying the wrong legal test in the UK tax context for business. Turning then to the Upper Tribunal and HMRC's response to that argument, the Upper Tribunal says at paragraph 229 that the First Tribunal must have been aware of the presumption because it was mentioned in passages quoted by the First Tribunal in the Salaried Persons and the Jowett case, paragraphs 75 to 78. And HMRC at paragraph 47 of the skeleton make the same point, asserting, quote, "It is not sustainable for GEFI to argue that the FTT somehow forgot to bear these principles in mind when reaching its decision 18 paragraphs later." In my submission, that is not an acceptable response when one looks at what the First Tribunal actually did in relation to issue 2 in respect of the authorities it actually considered. Now, I'm going to come on to identify as the third fundamental error of law the fact that the FTT didn't even consider 3 of the 4 important authorities that I have taken this court to. So the court did not directly consider American Leaf Blending, Korean Syndicate, or Westley at all. I'm going to come on to make that point. They were all cited to the FTT. They all form the basis of GEFI's analysis as to the meaning of business. The FTT didn't look at them. But over and above that failure, when one reads the First Tribunal decision, paragraphs 73 to 80, the FTT did nothing more than summarise the cases and copy and paste quotations from them. The First Tribunal does not engage with the authorities in any way. It did not state at any stage what principles arose from the case law or say what principles it was applying in its reasoning. And in my submission, that is a clear error of law in the reasoning of the FTT. And my learned friend at paragraph 49 of her skeleton quotes Lord Justice Henderson in Urenco, who absolutely rightly, in my submission, says the purpose of reviewing the authorities is to extract the principles of law which explain how they were decided. And as one would expect from his lordship, that is absolutely correct. But the First Tribunal completely failed to undertake that exercise. In my submission, the Upper Tribunal was entirely right at paragraph 226 to say, quote, the First Tribunal cited...
Would you dispute that a first-tier tribunal can accurately state the law without citing any authorities whatsoever, let alone discussing them?
It would need to cite the law, though, my lord. It would have to say what principle...
accurately state the law without citing any authorities whatsoever, let alone discussing.
But that would require it to actually state what law it was applying. And the First Tribunal does not at any stage set out what principles it is applying. All it does is copy and paste from a number of decisions and nothing else.
Well,
so
it's not necessarily the case that the first-tier tribunal is the right place to try and do some grand summary of what all authorities mean.
But it is right that the tribunal, I mean, from Lord Justice Henderson and many other authorities, it is right that one, both as a litigant, but also as an appellate court or tribunal, needs to know what principles are being applied. Otherwise, to take it to a pathological example, one could simply cut and paste every authority that has been cited and say, we give a decision. Now, we must have been aware of what was in the decisions because we've included them all in our decision. But that is, in effect, what the tribunal has done here. Now, the Upper Tribunal identified that at paragraph 226 and said, in my submission entirely correctly, the FTT cited case law without clearly identifying what the principles were and how they might be engaged. In my submission, the Upper Tribunal's failure was in not recognising that such an approach was, without more, an error of law in the FTT decision. But even to sort of somewhat sidestep the question about whether the tribunal was aware of the principles, whether you can say from the fact that it, in passing, referred to American leaf blending or it had quoted various passages, whether you can infer it was aware of the test, in a sense that doesn't answer the point anyway, because the reasoning doesn't engage with the test at all. So here, in the context of the strong presumption, there is no reference to the strong presumption, there is no reasoning that goes to the strong presumption. So in my submission, the FTT completely failed to apply that principle. There is nothing in the reasoning of the FTT to indicate that it took it into account, and neither the Upper Tribunal nor the First Tribunal are able to point to a passage where it did. Now, HMRC have two other arguments in response to this ground. They are at paragraph 46, which for your note is page 99 of the core bundle, tab 6. First, HMRC assert, and I quote, "It is not right that, quote, the making of loans to an associated company will constitute a business. It may do, it may not. It depends on the facts." Now, I don't understand the relevance of that sentence. It doesn't engage with GEFI's argument. The quotation that's included there isn't included in GEFI's skeleton argument, and I suspect it may be a typo. It may be a sort of cut and paste that is in the wrong place or something. The second argument comes after the passage where I've already taken the court to, where it is accepted as common ground that there is a strong presumption that a company will be carrying on business. And I said that HMRC say that's subject to 3 caveats. And so I need to address those caveats now. Noting, of course, that it is common ground that this strong presumption exists. First, it is said it's only a presumption, it is not determinative. My submission, that's not an answer. GEFI doesn't suggest that the presumption is determinative. It's a strong presumption. However, in my submission, the failure of the FTT to apply that presumption is an error of law because it applied the wrong legal test. I mean, to take a pathological case again, the presumption of innocence in a criminal trial is only a presumption. But if a court didn't apply that presumption, you can be fairly confident that it would be found to have made an error of law. Second, it is said the presumption applies where the company is pursuing one of its main objects. And then brackets, the LP's objects did not require it to carry on business. Now, there is no authority identified for that proposition, and in my submission, the proposition has no basis in the case law. It recalls, I think, the analysis that we looked at in American leaf blending, page 401, where Lord Diplock analyses Wesley and says, well, if you're carrying on, Wesley seems to say, if you're carrying on an object, then you are carrying on a business. And he says, no, that's only in respect of the principal object. That's a different point. That's not to do with the strong presumption. That's to do with saying, if you're carrying on your principal object, you are necessarily carrying on a business. So that's a definitive presumption or definitive conclusion. So it may be that there's some confusion there. But that, as I say, is a different point. And what is said, namely that the presumption only applies where a company is pursuing one of its main objects, just finds no basis in the case law and no authority is pointed to for it. Third, it is said that the relevant entity here is the LP, whose objects do not require it to be a business, as opposed to a company. And my submission, that analysis is also flawed for a few reasons. First, the issue that is agreed here is whether GEFI Limited was carrying on business. It's GEFI Limited that was seeking double tax relief, and it's GEFI Limited that would be taxable in the US under Article 7 on the basis that it carried on business in the US through a permanent establishment. GEFI Limited is a company, and so the strong presumption applies to GEFI Limited. Now, it's equally true and common ground, as I've already set out, that the LP's activities are attributed to GEFI Limited due to the fact that it's tax transparent. But in my submission, there's no reason given as to why that should mean the strong presumption does not apply to GEFI Limited. Further, and in any event, HMRC do not identify any principled reason why the strong presumption shouldn't equally apply to a Delaware LP. Like a limited company, it is an artificial legal person. It cannot be carrying out lending activities for pleasure or family obligation or for some other non-business reason. In my submission, the logic of the strong presumption should apply just as much to the LP as it would to a limited company. So, by way of summary of that first ground, the First Tribunal's failure to take account of the strong presumption in its analysis was a conventional error of law in that it failed to apply the correct test of business for UK tax purposes. Second fundamental error of law is the First Tribunal's failure to take account of the legal principle that it's not necessary for a company to undertake a significant amount or even any activity in order to be carrying on a business. In short, that there is no requirement for an active carrying on of business. In my submission, ultimately, the FTT's conclusion was very much focused on the activity carried out by the LP, how extensive that activity was. Now, GEFI do not dispute that the extent of the activity is a relevant consideration for the FTT to have considered. It is one of the Fisher factors. The FTT's error of law in my submission is its failure to recognise that as a matter of UK tax law, it's not legally necessary for a business to carry on any activity at all, and there is certainly no requirement for regular and continuous activity that the FTT expressly referred to at paragraph 84. And I've already, in a sense, made the submission that, in effect, what the FTT did here was to repeat the error of Mr. Justice Rowlett from his darkest days, that there was a requirement for an active occupation continuously carried on. But in my submission, it's been clear since the mid-1920s that there is no such requirement in UK tax law. So another way of putting it, the tribunal failed to recognise that the UK tax law test for business sets a very low threshold as to what activity is required, and had the FTT recognised that fact, it might have affected its conclusion. And that means it's a material error of law. Now, the Upper Tribunal doesn't address that aspect of the decision. The HMRC in their skeleton at paragraph 48 have a twofold response. First, it is said that American leaf blending, quote, only left open the possibility that there may be unusual circumstances in which a business will not require any activity. In the usual case, some activity will be necessary, and GEFI has not asserted that the business in this case is unusual in any way. Well, that doesn't really answer the point, because GEFI is not asserting that it was a business that carried on no activity. Clearly, the LP was carrying on some activity, so that point seems to be addressed to the example in American leaf blending of the possibility of there being a case where no activity is carried on. And second, it said that the FTT decision did not turn just on the volume of activity, but also on its quality or lack thereof. But in my submission, neither of those contentions answer GEFI's point. The UK case law that I've taken the court to, in my submission, clearly establishes that a company need not carry on significant or substantial activity in order to be carrying on a business. The FTT failed to take account in its reasoning of that aspect of the meaning of business for UK tax law, and had it done so, it might have come to a different conclusion. Now, this point is closely linked, and so I'm going to take points slightly out of order, but it is closely linked to the second of the specific errors of law in the FTT's decision that I identify in the skeleton argument, paragraph 68.2 of the skeleton. The fundamental error of law, I say, is the failure to take account of the principle in UK tax law that a company does not need to engage in substantial or significant activity. There's no need for an active carrying on of a business. The specific error of law, 68.2, and incidentally, there's no real significance to the distinction I'm drawing. I'm just saying they're two different errors of law. But the specific error of law was that the FTT was clearly at least positively influenced by the US law test for trade or business. And so, taking points slightly out of order, I am just going to make that the second of the specific errors of law that are identified in the skeleton. Now, I've taken you to the passages in the US experts' evidence that in my submission clearly establishes that the US does require a company to engage in continuous and regular activity. And if we could just quickly go back to page 806, just to do by way of comparison in the supplementary bundle. So it's tab 87, page 806. And it's the passage that I specifically relied on. Holding 5 affiliate loans over the course of approximately 6 years, only 3 of which were originated with the LP, is likely to be considered activity that is passive, sporadic, or isolated, rather than regular and continuous. Now, if the court would turn straight from there to paragraph 84...
Well, can we look at paragraph 73 first?
Sorry, paragraph 73 of what, my lord?
The FTT.
Yes. Yes,
They say, as it is the UK that's applying the convention in this case, it is necessary to consider the meaning of business as it's understood in UK law, and then we have citation, and you say wrong citation, but nevertheless citation for a series of UK decisions.
absolutely.
So you say, despite having directed itself that it was UK law to be applied and cited nothing but UK authorities, nevertheless they applied US law.
Well, a couple of points there. There were no US authorities point one. So there was only the US expert evidence that it could have looked to for the US test. Secondly, I fully accept that the tribunal purports to be applying the UK test. You have my submission that it doesn't actually derive any principles as to what constitutes the UK test.
Yeah.
But then when we come to its reasoning, having not identified what the UK test is, the only thing that was actually identified before the tribunal as constituting any kind of test for business that it actually refers to is, in my submission, the US law test. And that's in paragraph 84. So it's the passage we've just seen, starting from second line down, holding 5 affiliate loans over the course of approximately 6 years, especially as only 3 of those originated with the LP, is, in my judgment, more of a passive, sporadic or isolated activity than a regular and continuous series of activities. And then over the page as well, in the second line, there's a reference to continuous and regular activity. So the phrase is precisely, given absent one word, I think, which is essentially, that is lifted from the US experts' evidence. That is precisely the phrase that's used, and in my submission, the Upper Tribunal was again correct to note at paragraph 240, quote, the FTT referred to the US test for carrying on a business in its reference to a passive, sporadic or isolated activity. In my submission, the FTT was either positively relying on that test in its reasoning, if not ostensibly at paragraph 73, or at least substantially influenced by it in coming to its conclusion. And either way, given that the US tax law test for business is different to the UK tax law test, in my submission, that is a material error of law. Now, the Upper Tribunal response is to say, well, if one reads the judgment fairly as a whole, the FTT, I don't think, was applying the US test. And to conclude otherwise would be an example of a Greenberg-style hypercritical reading of the judgment. HMRC endorsed that response. In my submission, it is undeniable, as I've already submitted, that the First Tier Tribunal expressly referred to the US test in a crucial part of its reasoning. This is, of course, where the tribunal is considering the extent of the LP's activity, and that formed the basis of its ultimate conclusion. Indeed, my learned friend identifies paragraph 84 in paragraph 40 of her skeleton as one of 3 central findings made by the FTT. And in my submission, it is difficult to understand the Upper Tribunal's conclusion that the FTT was not at least significantly influenced by the US law test, for a couple of reasons. First, otherwise, why would the FTT have referred to it? And moreover, given that the Upper Tribunal had also held that the First Tribunal had not identified what the legal principles were in this case or how they might be engaged, the fact, as I've already submitted, that the one legal test that they did articulate and refer to was the US law test, in my submission strongly suggests that they were at least significantly influenced by it. And in my submission, that is not a hypercritical reading of a judgment. It is pointing out that the FTT expressly referred to the wrong legal test in the reasoning of its decision. Now, one other point that I do need to make in this context is to note that the Upper Tribunal did not take account of how HMRC presented the case on issue 2A to the FTT. So I am going to have to do a little bit of archaeology on that. Although it is
running out of time, I would point out.
Well, I'll have to be
3 o'clock, and your side started at 3 o'clock yesterday, so you've had your day.
My learned friend indicated that she needed an hour, so I'm going to try and be as quick as I can.
Yes, but unless you're giving up all your reply time.
Well, that may happen. Well, I will try and be as fast as I can, my lord.
All right.
I do need to show you these things, though. Very quickly, HMRC's amended statement of case is at page 44 of the supplementary bundle. If I could just ask the court to read paragraph 41.
41.
Yes, my lady. Now there, in the amended statement of case of my submission, you see the reference to, for the purposes of US tax law. In the statement of case, HMRC was specifically relying on the US law test of business. Now, if we come on to the skeleton argument before the FTT, the position is slightly less clear. Perhaps if I could give you the references, if at page 138 of the same bundle, there is paragraphs 93 to 94, a lengthy section on summarising the US law expert evidence as to whether an entity was carrying on a business. That is given in the context of issue 2 as a whole, so not specifically in issue 2A. But then a few pages on at 147 to 148, at paragraphs 111 to 114, this is specifically in the context of issue 2A, an express reliance is placed on the expert evidence, references to the activities not being sufficiently substantial, regular and continuous. At the bottom of 113, reference to passive, sporadic or isolated rather than regular and continuous. 114, according to be very surprising if the tribunal reached on the basis of the same facts considered by both US experts a different conclusion to whether GEFI carried on business in the US through the LP. So my submission, HMRC's written submissions before the FTT in the amended statement of case were positively relying on the US law test. In the skeleton, they are certainly asking the FTT to rely on it to some extent. And in those circumstances, in my submission, it is completely understandable that the FTT adopted HMRC's approach and relied to some extent on the US law test. It also undermines, in my submission, any suggestion that this ground of appeal is a hypercritical reading of the FTT decision. So that's the second of the specific errors of law relied on the US law test. Final fundamental error of law, I think I can leave it from the skeleton, but fundamentally the tribunal already has my submission. The court has my submission. The FTT did not refer at all to 3 of the 4 cases that
that implies it was obliged to do so. What authority do you cite to say that it is an error of law for a first instance tribunal not to cite authorities?
Well, in Urenco, for example, in a passage that has recently been endorsed by the Supreme Court, I can provide the decision. I can't give you the name of it offhand, but I can provide it. His Lordship talks about...
Suppose they'd cited a textbook and taken a sentence or a paragraph out of the textbook. And suppose the textbook actually contains some footnotes citing the relevant authorities, but the footnotes were stripped out. You say that's an error of law?
My Lord, I say that it undermines the cogency of the FTT's reasoning. And
so this results in a burden on the FTT that in every decision they've got to cite all relevant authorities, or else they're going to be accused of an error of law.
No, my Lord, but in a situation where parties relying essentially on 4 cases to substantiate the legal principles, 3 of those 4 authorities are not referred to at all in the reasoning. In my submission,
and you've cited no authority to support the proposition that that's an error of law.
My Lord, in my submission, Urenco is I can't give you the passage offhand, but I can find it, my Lord, if that would assist. Lord Justice Henderson says that something which undermines the cogency of the tribunal's reasoning, it can constitute an error of law.
But why is a mere failure to cite authorities undermining the cogency of the reasoning?
Well, it may be that it simply supports the proposition that they didn't identify any of the legal principles.
Yeah, but that's back to your first point.
Well, it may be an adjunct or support of that point. But
the first point I understand, but this at the moment seems to me to be utterly unsupported by authority and very burdensome for tribunals if accepted.
My Lord, I'm not for a moment proposing that a tribunal has to refer to every authority that is relied upon. But in circumstances where there are 4 principal authorities that are at the level of the Court of Appeal or above, for a tribunal to not have regard to them at all is, in my submission, clearly has the effect of undermining the cogency of the tribunal's reasoning. It may be that in the court's mind functions as an adjunct of the fact that it simply didn't...
You can't give very much further seriously, can you, than saying the fact that those authorities weren't cited raises a question mark, at least, about whether the tribunal properly appreciated the principles to be applied. And once you're into principle territory...
And if it considered them and it might have come to a different conclusion...
Yes, that's the test.
That's a material error of law.
But you've got to get through an initial gate to start with to say that there is an error of law. But the error of law is the failure to self-direct correctly on the law, isn't it?
My lady, yes. I would
split it out into 3 separate principles that it failed to take proper account of.
Indeed, yeah. perhaps I can't take the point any further. I would still submit that it is extraordinarily surprising that in circumstances where we were relying on effectively 4 cases of the higher courts, that 3 of them are not mentioned in the decision. That deals with the substantial errors. In terms of the specific errors, I think I can, given the time, I think I can leave those based on the skeleton argument. The arguments are set out there in full. I've dealt with the US law point.
Which paragraphs in the skeleton?
Oh,
All right.
It's
You've
paragraph,
dealt with the US
paragraph
law point
68.
already.
Exactly. I've dealt with the US law point. There are 2 other specific errors that are identified, I think, in paragraph 68. They are dealt with there, and I don't think I need to elaborate on them. In terms of the upper tribunal's errors of law, we identified 5, but in my submission, the only error that we actually need to address, because my learned friend accepts that we only need to establish an error of law in the FTT, is this final point, the 5th error, which is at the Upper Tribunal decision paragraph 241 to 243, where in my submission the Upper Tribunal purport to set out an alternative analysis of the FTT decision. It says there, and I'll read it rather than going to it. In essence, HMRC's case was that using a previously dormant company as a component in a tax planning adopted by the group, where the company was a passive investor in a limited partnership, and the general partner was directed to do things with a limited understanding as to why, was not an activity that could be reasonably regarded as a carrying on of a business. The mere fact that the transactions entered into by the LP were of a kind commonly entered into by persons carrying on a business and involved large sums of money did not mean that this particular company performing these particular acts was carrying on a business. To hold otherwise would itself be an error of law. It seems to us that in substance the FTT accepted this submission, even though it did not say in terms that it regarded GEFI Limited as a conduit company. It was, in our view, reasonably open for the FTT to do so on the evidence before it. Now, this passage is the main reason why I need to just briefly address the Upper Tribunal decision, because in my submission that reasoning is simply not found in the FTT decision. The FTT did not decide the case on that basis. It decided it on the basis of the amount of activity carried on by the FTT. And it's important to note that the Upper Tribunal was asserting that its reasoning entailed that to find that GEFI Limited was carrying on business would be an error of law. In my submission, the analysis is wrong for 3 reasons. First, it's wrong on the facts, because as the Upper Tribunal itself recognises, the FTT simply didn't make a finding that GEFI Limited was a conduit company. I've already submitted, there's no suggestion that the arrangements were legally ineffective or a sham, and there's no basis on which to disregard the reality of the arrangements concerning GEFI Limited or the LP. Second point is that the Upper Tribunal failed to consider all of the relevant findings made by the FTT, so it lists 2 of them, but it fails to note that the First Tribunal found that the LP was a serious undertaking, and more importantly, that the loans were conducted on sound and recognised business principles. They are further findings of the FTT of significant relevance to whether the LP was carrying on a business. But the third and most important point, and really the reason I just need to address you on it, is that in my submission what the Upper Tribunal appears to be doing is making an error of principle here. Because it appears that the only thing that the Upper Tribunal found objectionable about the arrangements was the use of GEFI Limited, as it said, quote, as a component in tax planning adopted by the group. And the Upper Tribunal analysis seems to be that the group tax planning somehow denatures the activities of GEFI Limited and the LP such that they cannot in law amount to business. In my submission, an argument of that kind is unsustainable. There is no authority cited in support of the approach, and it is directly contrary to a large amount of case law in the context of context of the concept of trade. That case law says that the fact that transactions are entered into with a view to obtaining tax benefits or tax advantages does not prevent those activities from being trade as a matter of law. Now, there are 3 authorities cited in footnote 28 of the skeleton, but actually the clearest statement to that effect is in an authority relied upon by HMRC. It's the Eclipse Court of Appeal decision. If I could briefly take the court to that, and then I've pretty much finished. It's tab 36, page 742. Sorry.
Say that again, page reference, please.
742, my lady.
Of
Sorry, tab 36.
the
Authorities.
Of the authorities bundle, my lady.
Yeah.
So it's Court of Appeal
Yeah,
in
got
Eclipse, one of the many
better
Eclipse or
okay.
film scheme cases. It's really paragraph 117. I just asked the tribunal to read that.
Yes, it says it's not determinative.
Indeed. Well, but the point there is that the Upper Tribunal seems to be saying, and I accept that what the Upper Tribunal is saying is not clear, but it does say as a matter of law
Yeah.
that prevents it from being a business. My lady, just very briefly to touch on, you asked about the Edwards and Bairstow point at the end, or I mentioned it and you looked quizzically about it. It might be said, well, if you haven't found an error of law in the tribunal's decision, what basis is there for an Edwards and Bairstow challenge? My submission, the relevance potentially could be, if this court were to agree with my analysis of the legal principles, but you were to say, well, we can't assume the tribunal didn't have them in mind, it could still be the case that this court could say, well, applying those principles, the ultimate conclusion is Edwards and Bairstow unreasonable. But as I've submitted, it's there very much as a fallback position, and it's only one paragraph.
But Edwards and Bairstow requires there to be no evidence to support a finding.
That's not correct, my lord. It's that there's no evidence, or that no reasonable tribunal properly directed
That's
itself.
perversity. You're submitting that this is perverse.
In Edwards and Bairstow, it's put three different ways as to by Lord Radcliffe. I think might have got this wrong, but I'm pretty sure it's Lord Radcliffe says there are three ways of saying it. There's no evidence. All the evidence points to a different conclusion, or no reasonable tribunal properly directing itself on the law could have arrived at that conclusion.
Which is what we nowadays
call
perverse.
Indeed, but it is one of the ways that it is said in Edwards and Bairstow that one can set aside an evaluative factual finding.
Yes, so my question is, are you submitting the FTC's decision was perverse?
Yeah, well, in circumstances where you agree with the legal principles that I've identified,
I think it's a yes or no question. Are you submitting that the FTC's decision was perverse?
Well, my primary submission is the First Tribunal made a conventional error of law by not taking into account the relevant legal principles. There is a world in which you say, yes, those principles are right. We are not prepared to assume the FTT didn't have them in mind. And if you get to that point, then yes, I would submit that the conclusion is perverse. I was going to briefly address, by way of conclusion, just how I propose the matter be disposed of. But essentially, I think, my lady, you have my submission that, and my lord, that if
we should remake.
You should remake. You shouldn't
Right.
remit.
We've got that submission.
I'm grateful, my lady. Can I just check with those behind me whether I've missed anything or said anything wrong? Unless I can assist the court further, those are my submissions.
Thank you.
Thank you, my lord. I intend to start with business first, since it's all fresh. If I could just pick up 2 points that my learned friend made at the end before I forget them. First of all, he talked about the Upper Tribunal's observations about GEFI being a conduit company. Ultimately, when you look again at the Upper Tribunal decision, you'll see that that was a furthermore type point. It wasn't material to the reasoning, so it wasn't directly part of the first tier's reasoning. Wasn't a material part of the Upper Tribunal's reasoning, so I don't think any further analysis of that takes us any further forward. The other point that I just want to address while it's fresh is remit or remake, and certainly before the first tier tribunal, we went through very extensively quite a lot of the documents, the minutes, so on and so forth. They're clearly, well, this court hasn't heard those submissions, all the documents aren't in law, and there clearly wasn't planned into the timetable enough time for that exercise. So in the event that this court finds that there has been an error of law, we currently don't see there being any other option but to remit to the first tier again with guidance that Judge Brooks remakes his decision based on whatever the court may decide is the correct legal test. Of course, though, we say there's no need to remit because there's no error of law at all. Now, bearing in mind the very full Upper Tribunal decision, and I should say that certainly as I have understood it, both in writing and sitting here today, my learned friend's submissions have very much been the same to this court as they were to the Upper Tribunal. The Upper Tribunal decision discusses them, addresses them, and rejects them in full. Again, my learned friend's submissions elaborated on his skeleton argument. Our skeleton argument has discussed them and explained why they're wrong in full. So I do not intend to repeat any of the submissions in our skeleton orally. I do take them as read, and I appreciate that this is my chance to respond fully, but I simply intend to structure it more like a typical reply, bearing in mind the timing, but also what we say is nothing to see here. So if I can just start off by making a few high-level points, then I will go to directly respond to my learned friends' oral submissions briefly. So in effect, what GEFI is saying is that a company that has objects including the holding of receivables, which holds 2 receivables and makes 3 further loans, must be carrying on a business where those loans and interest are large, regardless of any further surrounding context. Because the one thing we haven't heard is much in the way of argument, and it certainly wasn't in GEFI's skeleton argument, as to why the first-tier tribunal's decision and observations in relation to that surrounding context and those surrounding facts were wrong. In other words, GEFI's case needs to be that that surrounding context in which these things occurred is in effect legally irrelevant, because GEFI simply hasn't sought to address any of basically the unhelpful factual findings against it to any great degree. And GEFI's core problem in our submission is that none of the case law supports a conclusion that the bare facts of, well, look at us, we made big loans, the interest was big, those bare facts, regardless of surrounding circumstances, must equate to a business. None of the case law supports that conclusion. Ultimately, and unsurprisingly, the cases tell us that it all depends. And GEFI's complaint is in effect nothing more, and this is why we say it's nothing more than an attack on the FTT's evaluation, and that's something that's not open to it. Now, if I can just give, please, 2 brief examples which show the relevance of the surrounding circumstances in the authorities to the decision-making process on business. The first one is my learned friend's favourite case, American leaf blending. If I could ask you, please, to go to Authorities tab 19, and it's PDF page 401. And it's, so Authorities tab 19, PDF page 401. And it's the paragraph that begins the carrying on of business, no doubt. And if I could ask you, please, just to briefly read that paragraph between D and F. And so the point here is it wasn't simply, well, there are 3 successive lettings, QED, that's business because we're in a corporate context. The surrounding facts were relevant. They were negotiated with different tenants. There was removal of the machinery. There was then a separate letting to a fresh tenant, and then there was negotiation. So that's an example where the surrounding context is relevant. If I could go, please, to Tyre Investments, secondly, and that's Authorities Bundle tab 1313, PDF page 291. And I am just going to revisit the passage that my learned friend has already shown you. So PDF page 291. My learned friend's already asked, I think, the court to read the first 2 paragraphs. The second paragraph beginning the question before the commissioners. But again here, Mr. Justice Rowlett is having regard to the surrounding circumstances. the company being busy in itself in the most active way and occupying itself as an alert and astute shareholder. So it's not merely the holding of shares is sufficient without more. The surrounding context are what led the court to reach the conclusion it made. That's not surprising. Now, those extracts show that, let's assume for the moment you might have a case that you might see is somewhere in the grey area in the middle. The surrounding circumstances and activities and the quality of those activities can lead a court to the conclusion that a company is carrying on a business. It can also lead a court to the opposite conclusion that there's no business. That is the job of the court and the fact-finding tribunal to work out based on the evaluation. If I could ask you briefly just to turn up our skeleton argument, I appreciate the authorities that I'm about to show you will be familiar, but it's our skeleton argument on issue 2, so core bundle please, tab 6, PDF page 90. And we've set out at 47 the passage that no doubt is very familiar to, but with respect to my learned friend, much of the exercise going through the case is certainly before lunch and then his submissions on it afterwards, was essentially the failed exercise that the taxpayer...
Sorry, which paragraph in the skeleton?
I'm so sorry. It's paragraph 22, the
Thank you,
eclipse.
22. Eclipse, yeah.
So as I was saying, with respect to my learned friend, a lot of the oral submissions and submissions in the skeleton are essentially proceeding on the basis of this flawed exercise that was carried on in Eclipse and the Court of Appeal. And we already know, and you have the quotation from Urenco below, there are cases, and Urenco of course concern plant and machinery, and I'm very well aware that my Lord Justice Arnold is intimately familiar with Urenco, but it was said that there are cases in which it's possible to take either view without erring in law, and we say a test such as business is one such case, precisely because once you've got the bare bones and the bare principles and the relevant indicia identified, then it's a matter of evaluation, and that's a matter for the fact-finding tribunal. If I could ask, please, that we just turn to paragraph 40, so 40 of our skeleton, which is PDF page 96. Paragraph 40, so at the bottom of that page, we've essentially set out what we say are three central findings that the first tier made. And assuming for the moment, and my learned friend does not seek to say that any of the primary factual findings were wrong, but in view of those factual findings, it's a matter for the FTT to weigh up whether or not, as against those findings, the fact the loans were big and the interest is big tips the balance in favour of business. There's nothing in those findings that can sensibly be said to be an error of law or legally irrelevant. Now, one of the things that my learned friend pointed to is he pointed to the phrase passive, sporadic or isolated activity, and he said, what the first tier here did was apply the US test, and he showed the tribunal, it was page 806 in the supplementary bundle, and he put a lot of weight on the sentence, holding 5 affiliate loans over the course of approximately 6 years, only 3 of which originated in the LP, is likely to be considered activity that's passive, sporadic, etc. That wasn't the US expert setting out the US test. That was simply the US expert's own observations in evaluation as to the activity that was going on. Now, in the event that the first tier tribunal had decided to run passive, sporadic and isolated through a thesaurus and put different words on the page, we wouldn't be here holding that submission. The first tier tribunal plainly didn't apply the US test, The fact that it happens to have chosen language similar to the observations made by the US experts, because after all, that's a fair way of describing what the company was doing. It is neither here nor there. And what do we say about these key findings? As to A, so I'm still in my skeleton, 40 sub A, well, we say that's a conclusion of facts and evidence. Sorry, the facts and evaluation, and nothing in A can be said to be legally irrelevant. What do we say about B? Well, again, look at the case law. Those are relevant factors to take into consideration. And the same goes in relation to C. Moreover, as you'll see when you go down to paragraph 41, we set out the evidence before the first tier that led the first tier to reach those factual conclusions. And GEFI hasn't tried to say that the evidence is somehow flawed or that was a wrong conclusion on that they were wrong factual findings. And so we say that at that point it's clear this isn't a legal challenge at all. Rather, it's simply a challenge about the evaluation and the amount of weight that should have been placed on certain matters. Now, you already have seen in the Upper Tribunal's decision and in our skeleton, we say that in fact there were two errors made by the first tier, but both of which operated in GEFI's favour. And the first error, which is at, if I can just go briefly to it please, at tab 12 of the core bundle, I'm sorry, sorry, please bear with me, I've lost the relevant paragraph number. Yes. The first error is at paragraph 73, so that's PDF page 216. The reference there to town investments, and the Upper Tribunal deals with this very fully in its decision. Town investments is in a completely different context. And there, the court was deciding, well, could you talk about, is it sensible to talk about the business of government? Yes, we think it is, therefore business is being carried on, because the dictionary meaning could mean anything. So the context, as the Upper Tribunal very clearly deals with, is different. But we say that ultimately, having succeeded in circumstances where the first tier adopted erroneously adopted such a favourable, broad test to GEFI, it's quite hard for GEFI to row back and say somehow, no, that the first tier was too restrictive. We've already made the point fully in our skeleton that the second error that the first tier made was taking account of GEFI's objects as opposed to the LP's. And if I can just unpack that a small amount, the target of the search for who is conducting business, the number one target is the LP. Is the LP conducting business? All that happens is, if it is, that business treatment is then attributed to the limited partner.
Just to put a slight flesh on the bones there, essentially, to have the fixed place in the US, which I know is agreed not to be a separate point, you only get there via the limited partnership.
Yes, exactly.
So you must look at the actual activity.
Exactly. The actual activities of what the limited partnership itself was actually doing. And in circumstances where we know, when the Upper Tribunal says this in its decision, as a matter of Delaware law, a limited partnership does not need to be carrying on business, and the limited partnership's own corporate documents talks in terms of activities. It doesn't say that the limited partnership is set up to carry on business. If we're going down the road of asking whether, well, how strong is the presumption, because are we looking at a company in circumstances where it was the company's main objects that are being carried on? We don't have that situation here properly understood. Now again, the first tier decided that actually it was the limited partnerships, it was GEFI's memorandum and articles that were relevant. It accepted my learned friend's arguments on that front. But the important point is, having quoted from case law, which basically set out the corporate presumption, if I can call it at that. It then goes on to resolve the dispute between the parties as to whose article should we be looking at. Yes, okay, the first tier could have saved us all 5 minutes of oral argument in the Court of Appeal if it had set out a sentence saying, and I'm now going to put the two together. But one can't seriously say, well, somehow the first tier had forgotten about the corporate presumption, because part of the only reason for untangling the argument as to whose corporate documents did we look at was in order to deal with the corporate presumption argument. So yet again, the first tier fell into error, but that error operated in GEFI's favour. I had a couple of submissions that I would have taken the Court of Appeal to in order to show why remaking would be a dangerous exercise for this court to follow. In the interest of time, unless you particularly want to see those examples, I don't intend to go through any of the transaction documents in the bundle. And I'm simply going to move on to...
Are they, can I just ask this?
Yes.
The FTT deals in its findings of facts quite a lot with the emails and so on.
Exactly.
Would there be more that you would take us to?
Put it this way, in the FTT's decision, they are the most powerful examples, and they're not the only examples. So if we're considering the preponderance and the weight of evidence, I would have done an exercise of showing you more, but I simply don't think...
I mean, your overall point is it's an evaluation of all the facts.
Exactly. And you don't have the documents, you haven't heard the submissions. And yes, the FTT summarised the absolute key emails, certainly that we were referring to, but it wasn't absolutely everything. So I don't intend to do that exercise unless you have a particular question or you want me to take you to anything. So then what I'd like to do, just to wrap up on business, is just deal with, in the order the submissions were made, my learned friend's oral arguments. My Lord Justice Arnold made an observation at the start about what are we interpreting the phrase as carries on business and so on. And all I want to say to that is, of course, context is relevant. We're all agreed that the relevant word that we're looking at is business, but the surrounding context is relevant. That is why we say, for example, a case such as Town Investments, which was deciding business in a different context, isn't relevant to the interpretation for treaty purposes. There was then a discussion about, well, what are we talking about? Are we talking about the meaning, the definition of business? Just so you have our submission on that, there isn't a meaning, a single meaning or a single definition of business. Perhaps a better way of describing it, we would say, are certain indicia or factors recognised in the cases that point to business or that point to no business. And we see in particular that the Upper Tribunal very much refers to the Lord Fisher factors as indicia, and there's no hard and fast rule. And what, of course, that means is that once we've established there is no hard and fast definition, and all we're looking at are indicia, in the event that my learned friend can't identify a failure to take account of relevant considerations, or a wrongly taking into account irrelevant considerations, all you're left with is evaluation of indicia, and it's a question of weight for the fact-finding tribunal. My learned friend, as they did in fact before the Upper Tribunal, approached this in the same way, of having their four key cases: Korean Westleigh, South Bayard Railway, American leaf blending. And one of the key criticisms of the first tier was that it didn't pay enough attention to those cases. Well, we, of course, thoroughly endure Lord Justice Arnold's observation that you certainly can't and shouldn't expect a first-tier tribunal to go through every single authority that is cited to it. But the key point that we made to the Upper Tribunal is, well, what new principle emerges from any of those four cases that is materially relevant and that you don't find in the first tier tribunal's decision. And we say the answer is none. And if I can just give one example of why we say, well, it actually doesn't matter that the first tier didn't quote extensively from American leaf blending or seek to draw its principles from it itself. If we look at paragraph 75 of the first tier tribunal decision, which is core bundle PDF page 216, we can see that what the first tier does is it quotes from salaried persons' postal loans, where Dr. Avery-Jones started off by saying, by saying, I derive the following principles from the authorities. Principle number 1 is taken directly from American leaf blending. And you may recall in the cases, a few years ago, and I forget which case it was, but there was an exaltation, please can we not go every time there's a tax avoidance case all the way back to Ramsey, please can we just start at BMBF? And so I would point to this.
Now Rossendale, I think, is the...
I'm sorry?
We now start with Rossendale.
Ah, right, okay. Well.
I think actually you should start or focus on the most recent.
Well, but I think that I'm clearly out of date, and that very nicely, in fact, makes my point even better for me. There's absolutely nothing wrong with an approach that starts with a summary of the key principles taken from the older case law. And actually, that's something that we should all actively be encouraging the first tier tribunal to do. So far as I have heard, and actually the same is true in my learned friend skeleton, and we make this observation in our skeleton, I have not heard a new principle emerge that wasn't something that features in the first tier tribunal's decision. I just want to whip very briefly through what my learned friend said were the 5 principles that should emerge from the case law. We've covered this in our skeleton. I simply intend to make my best point and move on, as opposed to make all the points I might want to make on the 5 principles. So, first principle, he said, was business is a low threshold, it's wider than trade. And we say, well, look at first tier tribunal paragraph 73, where the first tier starts off looking at town investments, which in fact is even wider than it needed to go. You can't seriously say that the tribunal applied too restrictive a test. Then my learned friend says, so his second principle, where there's the distinction between the company and the individual and the strong presumption. I say, we'll look at paragraph 75 in the FTT, quoting from salaried persons.
Strong inference. You see, it's not good enough. It doesn't say strong presumption.
I'm sorry. Prima facie inference, in fact. Oh, the inference is a strong... I'm so sorry. I've been paying too much attention to listening and not enough to reading. Apologies. Strong inference.
It says prima facie inference.
Well, I think then it says the inference is a strong one in the sentence. So, yeah. I'm sorry, I've lost my train of thought. So strong inference, no material difference between strong inference and strong presumption. And on any view, that the first tier already gave GEFI the benefit of the doubt in its approach to whose corporate documents to look at. Then the third principle that my learned friend relies on, well, business can be passive with long periods of quiescence. And our top point in reply is, well, the first tier at no point suggests otherwise, and its main reasons that I've already shown you, what I call 3 key submissions, are focused in particular on the quality of activity, such as it was, not just the quantity of activity. And all the case law ever says is you could have a passive business. It certainly doesn't say a company carrying on activity, even if it's passive, must be in business. Then after the short adjournment, my learned friend made his submissions on engaged in trade or business and the first tier wrongly adopting the US test. I've already made my submissions on that. My learned friend showed you a couple of passages of our pleadings below. Not that it matters, but we also made a point in the transcript. The transcript is not in the Bible, which is to say we're not adopting. We don't say that the US test is the right test or authoritative or binding. So we certainly weren't relying on the US test when it actually came to the hearing itself. And you already have my submissions.
Sorry, you actually submitted that to the FTT.
So can I, I think it's, if I could just, those behind me have sent me a copy of the transcript. It's not in the bundle, but would it help if I just read out?
It may do.
Just in case it
Yes.
matters. Yes. So
this is in the FTT.
it's in the FTT transcript, and I'll just read in for the purposes of the record. It's day 3. I think that must be page 142. So what I submitted was, while we're here, it's convenient to run through the evidence in relation to the US position in business, and we've set that out in paragraph 93. Just to reiterate, we're not saying that this somehow proves or answers the UK test of business, but what we are saying is, let's look at how the US approaches its test of business, and in due course, the point I made earlier, we will actually see that they're similar. I think I meant that the tests are similar. So it's informative, although we certainly don't say it's authoritative or binding or anything like that. And it's up to the first tier to make its own to make its own choices as to what influence it decides to place on the US test. And in the end, it didn't place influence on the test simply by virtue of choosing a few adjectives that were similar to how the US experts viewed the activities. My learned friend's then fourth principle was to say the purpose and the object of the company was the relevant factor, and I've already explained how the first tier approached that wrongly to their advantage, to GEFI's advantage on any view. My learned friend then moves on to Lord Fisher, and certainly my note of the way he put it was that the first tier was entitled to have regard to Lord Fisher. But we say, well, that's all the first tier did. There's no error of law there. In having regard in due course to Ramsey, Ramsey in turn had regard to Fisher. No error of law there.
Well, Ramsey also considered American leaf blending.
It did, exactly. And once you've accepted that the first tier tribunal was entitled to have regard to cases such as Ramsey and Fisher, which set out nothing more than indicia, then really my learned friend's complaint, properly understood, is actually just about weight, the weight given to the various different indicia. My learned friend then went on to talk about the errors and to talk about what the LP did, and he couched it in terms of carrying out very substantial transactions, so in effect big loans and big interest, and you've already heard my submissions as to why that of itself is not sufficient to amount in law to business. Then a lot of my learned friend's complaints about the first tier's errors were really criticisms, we say, about the writing of the decision, as opposed to identifying any divorce material errors of law, if I can refer to them like that. And much to my surprise, that's in fact all I had. So unless I could help you further with anything on business, I was simply going to move on then to deal with my reply now to residents. So if I can start off, please, with a couple of miscellaneous points, just so it's in the transcript. My learned friend referred during the course of yesterday to a statement supposedly made by our expert, and he put it that the share staple had an analogous effect to incorporation in the US. When you actually look at the report, it's clearly expressed as being so far as concerns taxation in the US. That's literally the words used in the expert report. So quite apart from the fact that our expert had no relevant expertise, he specifically was not trying to make any further point about a similarity beyond tax. The reference for that, we don't need to go to it, supplementary, tab 88, PDF page 830, and then it's question little Roman 6, paragraph 28. As my Lady Justice Falk observed earlier, cousin is indeed referred to quite extensively actually in Alter Energy, and your ladyship picked up on one of the examples. PDF page 955 shows that it is the 2002 version that we're looking at in our bundle. Now, moving on to the substance of Malone and Friend's submissions, if I can start with his submissions, excuse me, yesterday afternoon. We say that listening to his submissions for the last hour of yesterday as a whole, no real additional arguments emerged that I haven't already dealt with, saved for, in effect, assertions that GEFI's interpretation has to be the right one. The only additional justification that I understood, and I may not have understood it correctly, but certainly my understanding was that if HMRC's interpretation was right, then there risked being some kind of lacuna whereby someone could be taxed fully in 2 contracting states but treaty resident in neither. And with respect, we simply don't see that as a realistic outcome. It's not a real world outcome. Bearing in mind the complete improbability of 2 contracting states imposing worldwide tax with the person, or with a person that has no relevant local connection to either of them. So the reason we are having this dispute today is because GEFI very much is a UK treaty resident, having an argument as to whether it's also US treaty resident or not. But it's quite hard to imagine in the real world a situation where the 2 contracting states' laws are going to be such that they are both merrily imposing worldwide tax on the same person who somehow has no underlying links to either of them. He then moved on to his submissions as to, well, what is the genus? Now, I don't understand anything my learned friend said yesterday afternoon to have advanced any reasoned basis or any rationale why the genus can't be, as we put it, or as Vogel put it, in the sort of most pithily quoted version quoted in the Indian Tribunal, locally related attachment that attracts residence type taxation. Now that's a composite criterion. It's a common thread running through domicile, residence, etc. I don't think it would be useful for us being counsel to pose this as a, well, is it one criterion or 2 criteria? From our perspective, it's a single composite criterion, and that's what it is. And you already have my arguments on why we say that the need for a relevant local connection runs through the rest of Article 4, so the rest of the article itself, and that's relevant in principle, bearing in mind the background rationale as to why the resident state should have a better claim over passive income, and I've already taken you to the passage in Alter Energy about that at paragraph 74. This is all about working out who should truly be the resident state. One can also see from a practical perspective that there's an additional reason why the composite criterion should be the right one. One of the functions of the tax treaty is obviously certainty, as between contracting states and as between persons and contracting states. And if there was no connection requirement through Article 4.1 at all, and all that mattered was liability to worldwide tax without more, then certainly so far as the US-UK treaty is structured, there'd be substantial uncertainty, since in every case the taxpayer is then forced into an Article 4.5 situation, which we looked at yesterday, in effect whereby the contracting state shall endeavour to determine the mode of application via map. Our interpretation, on the other hand, provides certainty, because the taxpayer can look at it and say to itself, well, I'm only stapled. Stapled is simply an amendment to our corporate documentation. They don't have it. GEFI in the UK don't have any relevant local ties, not US treaty relevant. The end. Without being forced into some process which requires the member states, the contracting states to argue it out under MAP, which would inevitably be my learned friends, be the consequence of my learned friends' analysis. So moving on then, if I may, to my learned friends' submissions this morning. Running through them in order, my learned friend started off referring to paragraph 8 of the OECD commentary and the notion of deeming. You already have our submissions in response to that, which is essentially, which is essentially there are two types of deeming. See the comparison set up at Fowler, paragraph 25. PDF 873 of the authorities, and you certainly can't read into the OECD commentary that the OECD commentary and commentators had every type of deeming in their minds when they made the rather bold statement they did. My learned friend, and there was then the discussion about the blue logo example. And let's assume, for argument's sake, that we want to turn that into, well, what if there's something that treats all foreign subsidiaries as resident, which was, I think, my lady's way of putting a similar sort of example. My learned friend's two arguments to that were, well, one, we deem to know each other's laws, and therefore somehow the UK loses out in this case because it's deemed to know that the US sees stapling as being treaty resident. But the counter to that is, well, obviously all contracting states are deemed to know the interpretation of the treaty they entered into. This is why we call it a make-weight argument, a bootstraps argument. And I've already dealt with the point about good faith, and so I don't intend to rehash that. My learned friend then took you through the Upper Tribunal's 5 points on the commentary. We've dealt with those in detail in the skeleton. I don't need to add anything to what we've said in the skeleton. When my learned friend was going, sorry, I think I might have missed a point. Sorry, please bear with me 1 minute. When my learned friend was going through his submissions on the commentary, he didn't deal with paragraphs 10, 23 and 24, which are PDF pages 103 and 105, which I took you to in opening. And those are the only 3 paragraphs that actually use the word criteria, use the term nature. And it's very clear that those 3 paragraphs are all talking about criterion and nature in terms of relevant local connections and not merely subject to worldwide tax. I don't think I have anything more that I want to say about the second sentence of Article 4.1, save that, as my Lady Justice Falk rightly observed, picking up on one of the points I made in opening, the second sentence is materially different in our convention because of the reference to treatment in relation to permanent establishments. So it necessarily goes beyond dealing with mere diplomats. So whatever the underlying policy behind the subsequently very generalised drafted second sentence in the OECD Model Convention, clearly our treaty that we are concerned with has moved away from that and has expanded it again. Now, I still don't understand Even if my learned friend is right about his submissions on the second sentence, and for the reasons I've just explained, he just isn't, even if he is right, we still have heard no clear explanation as to why we are therefore necessarily wrong in our interpretation of the first sentence as requiring the composite criterion of relevant local link plus worldwide taxation. Nothing I have heard gives any sort of framework that linguistically means that our interpretation just can't hold on the words. Moving on then, I think my learned friend then moved on to the case law. You already have my submissions on Crown Forest. I just want to do, and I don't think anything that Crown Forest can say on the second sentence it is at all transferable to our case, because in our case, our treaty has the additional words that weren't present in the second sentence in Crown Forest. I just want to be very clear, because I think my learned friend may have misunderstood what we were saying the ratio of Crown Forest is, but I just want to be clear. We say the ratio of Crown Forest is simply worldwide taxes necessary, full stop. Any comment in Crown Forest that might suggest the court is saying that worldwide tax is sufficient can only be obiter. And I hope that clears up any doubt as to what our position is on Crown Forest. In relation then, moving on to alter energy, all I think I need to say in reply is that it is not part of the ratio that worldwide tax is sufficient. It simply can't be part of the ratio of alter energy that worldwide tax is sufficient. And I don't think I need to take the court to this, because the court obviously is going to have to read the case carefully on its own after the hearing. But certainly as we understand the workings of the GAR, the treaty permitted treaty residence by virtue of incorporation. That's the parallel issue here. It was not contrary to purpose, therefore, that there was no sufficient substantive economic connection. That's a very different exercise to the one we're looking at here. It's not the same underlying issue. Here we accept that a formal legal tie is sufficient because of the featuring of the words incorporation and citizenship, and we say that GEFI simply doesn't have one. Also, as you'll see in due course, it wasn't the Canadian Guard didn't operate to say you're not treaty resident. So it wasn't about turning off treaty residents. As we understand the operation of the GAR operated in effect a bit like the abusive rights principle to remove the so-called claimed benefit. So nothing you can take from alter energy helps my learned friend in establishing his submission that worldwide tax is sufficient. I've already shown the court in opening to those passages in alter energy where actually the court clearly says that the entire composite criterion is the right one. My learned friend then moved on to look at the Indian Tribunal case, the only point that I think I need to pick up on there is he said, oh well, but in this case, the type of taxation was source taxation only, so that would never have satisfied the requirement for treaty residence. Our point is, well, hang on a minute, that's not actually the way that the Indian Tribunal sought to decide the case. If you accept for the moment, as the Indian Tribunal did, that the relevant test is locally related attachments that attract residence-type taxation, any tribunal or court faced with any question where neither are satisfied can quite happily issue a decision on one or other basis as it sees fit. And the way that the Indian Tribunal decided to approach the exercise was to decide the matter by reference to the absence of the locally related tie. I'm not sure I quite understood my learned friend's, moving on to the Portuguese case, my learned friend's criticism about the Portuguese case, because certainly the way we read the judgment, it seemed to simply be quoting from a judgment, a previous Supreme Court judgment, that the court will read that on its own and form its own view as to the passage that we were relying on. It wasn't quoting from commentary. That certainly isn't the way that we read the decision itself. Yes. My learned friend then referred to the IFBD Editor's Note, Authorities tab 60, PDF page 1425. We have 3 comments on that. It's simply assertion without any reasoning or authority. It also contradicts the UK's own approach to Fowler with regard to deeming provisions. And it also puts too much weight on the anti-avoidance context of the underlying Portuguese the underlying Portuguese provision. Contrast alter energy, where alter energy in effect says, well, just because you're in an avoidance scenario, you still apply the treaty according to its own terms. That's our response on that.
You say it contradicts Fowler, the approach in Fowler?
Yes, so the way that I read the editorial note, and obviously your ladyship will form your own view when you read it, but the way I read that editorial note is one of the criticisms the editor makes of the Portuguese court would be contradicted by the approach in Fowler to deeming provisions.
Thank you.
Moving on then to academic writings, my learned friend suggested that Vogel support, properly understood, Vogel supports him, not us. At the end of the day, the writings say what they say, but just so you've had our response on that, Vogel doesn't support on any reading GEFI's articulation, GEFI's argument, because the one thing it does do is it rejects what it calls the functional interpretation, being the interpretation by reference to which you only have liability to worldwide taxation. The only uncertainty that may arise from Vogel and Vidrig is possibly in relation to the strength of the link required. Now, I've already explained why, hypothetically, it may well be that incorporation and citizenship might be necessary for some countries to include, such as the US, if, for example, they see the concept of domicile as being different to how we see the concept of domicile as requiring, in the US, for example, some underlying substantive links. These texts aren't written from an English lawyer's perspective. They're written by international authors for an international audience. So it may well be that some of the niceties of domestic law is lost, but fundamentally, the thread running through both is you do still require that underlying local link. In relation then to cousin, just to recap, and you'll see this again yourself, so I'll just read the references into the tribunal. I think my Lord Justice Arnold pointed to, it was PDF page 1231, in relation to a passage, I forget the precise words, but in effect supported HMRC's position. My learned friend tried to explain that away as essentially saying, oh no, cousin here is really just talking about the inconvenience of certain labelling. I say when you read the previous paragraphs, it's actually correct that cousin is, my learned friend is not correct. What is correct is that cousin is actually talking about the substance, not merely confusion that might be caused by attaching certain terminology. I think moving on then to the final piece, which is the application, I think all I need to address is at some point my learned friend made a submission, and forgive me if I've written this down wrong, I don't think I have, but if I have I apologise, that the first tier treated the differences in the tax treaty or the tax treatment as being determinative. Determinative was the word that I noted. We say when you read the first tier decision that's not the case. Whatever the first tier may have said about the US law.
You mean the differences in US tax law?
The differences in US tax law. It certainly wasn't a point that the first tier was treating as determinative. The first tier was focused on the concrete links, the substantive local links, and found against my learned friend on an evaluative basis. My learned friend then finished by raising certain criticisms about the fullness, not sure if that's the word, the fullness of the first tier reasoning, but that certainly isn't a material error of law. It's not a failure, it's not an error of law to fail to set out its interpretation, as fully as my learned friend may have liked it. The only error is an error in the niceties of decision making. But it's clear why the first tier concluded that my learned friend lost on application, and so therefore nothing more can elevate the decision making, the decision writing to any error of law, and it's a clear group type argument. If I may just have a quick look to see if there's anything else I need to add. I'm helpfully told no, so unless you have any further questions for me, those are asked.
Only one question, if I may, from me. There was a lot of debate about paragraph 3.2 and which lens you look through. Ultimately, I'm not sure it matters for this case, but we did hear rather different submissions from what you provided to us. You said essentially it's we got to look at it through a UK lens because we're applying UK tax, and the contrary submission was, well, this must be a case where the context otherwise requires. So you go to 4.1,
yes, sure.
and then the submission was look at UK, US, and international.
Something else.
I think.
Yeah. Yes. Okay. So actually, if I could just read out clearly, hopefully, our position into the transcript, if that's helpful. So our starting point is Article 3.2 tells us that when we look at the word residence, domicile, citizenship, incorporation, when we look at those place of management, those 5 words, your lordships, your ladyships, the court needs to look at them with UK eyes. What do those words say to you as UK lawyers practicing, as UK judges practicing UK law? So that's our submission. What we then say is assume for the moment that your ladyship happens not to accept that, and we're supposed to look at those terms from through US eyes. I would say that would be a surprising outcome. Because that would seriously overcomplicate these sorts of proceedings. If every time we're to have a treaty debate, we have to go and find expert evidence on the local laws as to what their local law and understanding of residence, domicile, etc., means. So that's why I say that the UK approach is right. Now, in our case...
Okay, so just applying here, yes. You'd say we're working out whether something is domiciled, etc., in the US, but looked at from a UK perspective of understanding of those concepts.
Is it subject to worldwide tax in the US? Yes. So we know it's liable to tax in the US. Yes. Now, when we're assessing what the link means, we have to say, well, what does residence, domicile, etc. mean to us as UK judges and lawyers? And therefore, that's the footing on which you interpret those words.
Can I put a different
Yes.
perspective as I put to Mr. Baker? I don't think it affects your case,
No, it doesn't.
but the perspective that I was putting to Mr. Baker is that the issue before the court is the proper interpretation of Article 4.1,
Yes.
and specifically the words or other criterion of a similar
Yes.
nature. And what I suggested to Mr. Baker was that that is an issue of public international law, as to which we apply international law, meaning that we apply Article 31, primarily the Vienna Convention, and Article 32 to the extent it's relevant. That is to say, we interpret it according to the wording, the context, the object and purpose, and it's common ground that takes in the fact that the UK-US treaty derives from the OECD Model Convention, and by that route you can also take into account the commentary on the OECD Convention. But the exercise is one of interpretation of those words in the treaty. If you have a dispute as to whether somebody is resident within the meaning of the treaty, or whether their place of incorporation is in a particular state, then for that purpose you have to employ the domestic law of the state in question, which here is the UK. So if the issue was whether GEFI was incorporated in the US, then we would apply UK law to determine that issue. But that's not in issue, as you've pointed out. It's common ground that GEFI is incorporated here, and the question is rather whether its liability to worldwide taxation arises because of another criterion of a similar nature. In the US, that is. So, do you have any submissions to make on that way of looking at it?
So, I'm sorry, when you said just at the end, another criterion of a similar nature in the US, that is, could I just make sure I properly understood the last phrase?
Well, so the question is, does the stapling and its tax consequences in US law, which everybody agrees is the tax consequences worldwide taxation is a matter of US tax law, but the issue is that a criterion of a similar nature?
I think, my lord, that we do agree with your lordship's summary.
Fine.
Yeah. Yeah.
That's nice to hear.
I certainly don't hear any shocks of surprise behind me. So I think that we would agree with that position. And then if I can just conclude the submission, what we then say is even if that's somehow wrong, we fall back on Fowler and the effect of the black equals white deeming. We also have made the point already that on any view, there's no evidence as to what domicile, residence, etc. mean to a US lawyer, therefore
That's
they
why I
should be
said I didn't think it
interpreted.
made any difference.
Exactly.
But I just
Through
wanted to
UK
clarify.
eyes on any view.
Thank you.
If I could make just one more short point, because I just, I suppose, but bearing in mind this is for the revenue, and so I don't want to find that I've somehow confused the issue in terms of how they actually do see things, so that we've got an incorrect submission noted down. I think that I do agree with your lordship's statement, but can I just make one other point? Assume for the moment, I think we are saying the same thing, that we were just looking at the Model Convention, and we in the UK had a treaty that didn't include the word incorporation, that was residence, domicile, place of management, and we in the UK had to ask the question, it's a UK-Bangladesh treaty for argument's sake. Well, we're looking at a company that has been incorporated in one or other contracting state. We in the UK, so certainly the way the revenue would do that exercise is to say, well, what does the word domicile mean to us?
To be sure.
Yeah, to us in the UK, it also includes incorporation.
Yes.
Therefore, incorporation is a criterion of a similar nature.
But that's because the issue is it domiciled? And the question is, to decide that issue, we apply UK law.
Yes.
But that's different to the question of what is covered by other criterion of a similar nature.
Oh,
If you assume that it's not domiciled.
I see. So I think the way that I was approaching it was to say, well, we have this thing called incorporation. To us, incorporation is of a similar nature to domicile. Therefore,
You're under.
No, it is
Stop it.
domicile. It is domicile
Well,
under Arnold.
Okay, so I think though we ultimately get to the same place in terms of the only point that I'm concerned about not misrepresenting HMRC submissions on is through which lens do we look at the words residence, domicile, etc. But I think you have my
The
submissions
individual terms
Yes.
are plainly viewed as a matter of UK
Yes,
law.
thank you. So that's all I wanted to be clear about.
That I had
Yeah.
grasped.
And the any other criterion then is just a more broad application. Yeah. Yes.
Yeah.
Thank you.
Very
Sorry for any confusion. So then those are my submissions. Thank you very much.
Thank you. Any reply on business?
Just a few quick points, my lord. I will try and rattle through them as fast as possible. First point, you have my submission as to what the relevant legal principles are as to the meaning of business. In my submission, those principles exist. There is nothing in the reasoning of the FTT in 81 to 91 of its decision to indicate that it was applying those principles. In my submission, fundamentally, that is the error of law in the tribunal's decision. Moreover, if those principles are right, and obviously I submit that they are, then in my submission, on the primary facts found by the FTT, there is only one conclusion that the tribunal could have come to, and that is that GEFI was carrying on business. Fundamentally, to address the point that my friend made about remission or remaking, in my submission, that's why this court can remake the decision. You have the primary findings of fact by the FTT. On the basis of those primary findings, and on the basis of the principles I've outlined, there is only one reasonable conclusion, and that is that GEFI was carrying on business. My learned friend made 2 points, which were in effect to endorse what in my submissions are errors that the Upper Tribunal made. I didn't address you on them. I will address you on them briefly in order to reply to what my learned friend said. The first is to say the Upper Tribunal considered, in effect, there were 2 errors that it said went in GEFI's favour, and almost this sort of gave some sort of buffer in favour of GEFI. What it said was the first of those errors was that it thought the First Tribunal was relying on the Town Investments decision. Now, the FTT did refer to the Town Investments decision at paragraph 73 of its decision, and it quotes from that case. The Upper Tribunal then, and I won't take given the time, I won't take the tribunal to it, but I'll give you the references. The Upper Tribunal at paragraph 227 takes the First Tier Tribunal to have been relying on Town Investments because the First Tier Tribunal at paragraph 83 refers to, quote, serious undertaking. So it's right at the beginning of the FTT's, and now very close to the beginning. Although there can be little doubt that the activities of the LP fit the description of, quote, a serious undertaking. And the Upper Tribunal says, well, in doing so, the FTT was relying on the Town Investments case. That test is too broad, and the FTT was wrong to be relying on it. And this, it says, is an error that operated in favour of GEFI. And at 244, it suggests, well, given that this error was in favour of GEFI, that's in effect another reason why we shouldn't set the decision aside. My submission, there is, in this context, no error on the part of the FTT in referring to a serious undertaking at paragraph 83 of the FTT's decision. That is not a reference to Town Investments and Lord Diplock's judgment in that case. None of the lords in the House of Lords in Town Investments used the phrase serious undertaking. My submission, it is absolutely obvious that what the First Tribunal was doing in 83 is referring to the Lord Fisher factors. And a serious undertaking is one of those factors. Serious undertaking earnestly pursued. But it's not anything to do with Town Investments. If anything, this rather highlights the fact that it's very difficult for the Appeal Tribunal to know what principles the First Tribunal was applying, But clearly, in this context, the Upper Tribunal, in my submission, just clearly got it wrong. That is not, in 83, the FTT referring to town investments. It's simply referring to the Lord Fisher factors. So that was not an error of law on the part of the FTT, albeit the Upper Tribunal thought it was and said it operated in GEFI's favour. Next point, and following on from that, my own friend said, well, the First Tribunal referred to GEFI Limited's articles, and the Upper Tribunal went on to say, well, it was fully entitled not to do so. The FTT, in my submission, entirely correctly quoted the relevant objects, of GEFI Limited at paragraph 6 of the decision. If you'll note, that's page 194 of the core bundle. Those are correctly quoted. In my submission, the FTT was entirely right to do that. The Upper Tribunal said, well, actually, it's the LP that's relevant, and the LP's objects or purposes are not limited to business objects. My submission, first, the Upper Tribunal wrong in two respects there. First, there was no basis for finding that the objects of GEFI Limited are an irrelevant factor, as it said. We've seen from the case law that the objects of a company are highly relevant to determining whether that company is carrying on business. And ultimately, that is the question we are concerned with, albeit fully accepting that it's the LP that is carrying on the relevant activities. The Upper Tribunal doesn't identify any authority to the contrary. Secondly, of those articles that are cited in paragraph 6, or quoted in paragraph 6 of the FTT decision, Article B, and I don't propose to take the Tribunal to it now, but it is there on page 194, to hold directly or indirectly financial receivables, that precisely describes the actual activities of GEFI Limited. That is what GEFI Limited was doing. It was indirectly holding financial receivables through the LP. And in that respect, also, the Upper Tribunal's analysis fails to recognise the common ground that the activities of the LP are attributed to GEFI Limited for the purposes of determining whether or not GEFI Limited was carrying on business. And I've already set out that that was common ground. But also, the Upper Tribunal makes the error that, in my submission, the fact that the LP's objects were not confined to business objects is, in my submission, irrelevant. The LP's objects are very short. They're in the supplementary bundle, tab 15, page 385. If I could just take the call there. It's 385 of the bundle. You can see the purpose, which is the equivalent of the objects for the purposes of the LP, is at paragraph 2. I could just ask the court to read that. In my submission, the primary purpose there of the LP is plainly a business purpose. In my submission, it is irrelevant that it may have other objects. There's no suggestion in any of the case law that an entity must have exclusively business objects or purposes. And of course, many companies or entities, certainly historically, would have had objects that were not exclusively business objects because people would want to ensure that anything the company did was intra vires the objects of the company. The key point in my submission is that the LP was carrying out its primary object, and that was a business object. And the Westley analysis, as considered in American leaf blending, would lead to the conclusion that that is conclusive of the fact that it is carrying on business. Its primary object is a business object, it is carrying on that object, therefore it is carrying on business. But on any view in my submission, it points very strongly in favour of that conclusion. So in summary, in my submission, the Upper Tribunal was wrong again to find in this context that the FTT decision, which did have regard to GEFI Limited's objects, was an error of law. The FTT was entirely entitled to take into account GEFI Limited's objects, and also the basis on which the Upper Tribunal says that the LP's objects are in some way telling against GEFI Limited is wrong. Two very final points that are very short. My learned friend in her response read out her submissions to the FTT, which, as I heard it, the submission was to say that the UK and the US law tests are similar. Well, for all the reasons that I've set out, that is simply wrong. So to the extent that my learned friend was commending the US expert evidence as a similar test, where the US experts had said that for US purposes, GEFI wasn't carrying on business. Again, that simply, if anything, reinforces the fact that in paragraph 84, the FTT in my submission was relying on the US test. And the final point to make from my learned friend, and again, what I jotted down was, it was said that our complaint was about the writing of the First Tribunal decision. That is correct, but I asked non-rhetorically, what is there beyond the writing of the decision? We are looking at what the First Tribunal produced as its decision. And if in its reasoning it didn't refer to relevant legal principles in my submission, that is a clear error of law. Unless I can assist further. Those are my submissions.
Thank you all for your submissions, which we will consider. Judgment will be reserved and handed down remotely with no attendance later. I'm not going to promise you as to when. You will get a draft for correction of typographical errors only, and to try and agree a consequential order if you possibly can. That will be under embargo, which must be strictly observed, as I'm sure you're all aware. And if you can't agree the order, then brief written submissions, please.